This video is about the directive from the Office for the Minister of Financial Services and Superannuation that ran the Australian Securities and Investments Commission case against one of the 155 financial advisors that invested in Trio Capital products. New evidence confirms that a senior ASIC lawyer said ASIC's prosecution case against the financial advisor is being run by the Minister's office. The Trio victims mailed a copy of the new evidence to Senator Andrew Bragg on the 25th of July 2023. This video avoids identifying the individuals mentioned in the letter because the matter is before the Senate inquiry.
This inquiry is principally focused on how ASIC deals with reports of misconduct.
Some of the responsibilities of the Superannuation Minister in 2012, such as consumer protection and consumer rights, including the regulation and oversight of financial services and superannuation, and to ensure that superannuation funds operated in the best interests of their members. Part of the Australian Securities and Investment Commission's role in 2012 was as an independent government agency responsible for regulating and enforcing laws that govern Australia's corporate, market and financial services sector. It ensured these sectors operated in a fair, transparent and efficient manner so that consumers and investors are protected. Both ASIC and the Minister did not stand up for these claims in regards to the Trio Capital matter. In fact, the following video shows they did the opposite. To a sector of the financial market, they were destructive. A number of troubling points and potential conflicts of interest concerning the Minister's involvement, which ASIC should have known about. For example, the Minister had a long history and connection with the Australian Workers' Union. Unknown to the public, the Australian Workers' Union had a slush fund called Officers' Election Fund, and it had its money stolen by the Trio Capital fraud. The financial advisor the Minister's office pushed ASIC into prosecuting was one of 155 advisors that had clients exposed to the Trio fraud. It just so happened he was the financial advisor that had recommended Trio products to the Australian Workers' Union, and the Australian Workers' Union Office Election Fund, its money was the union's war chest, money that could have funded a campaign for the next Prime Minister of Australia, which the Minister was a candidate. Other troubling facts in the Minister's background raise questions about appropriateness of the Minister's involvement in handling the Trio matter. For example, the Minister's decision to prosecute the advisor helped destroy the do-it-yourself sector, and that was a market competitor to the union-led super funds, and that the Labor Party also received revenue from the union-led industry super. It was ASIC's responsibility to prevent and address practices that lead to exploitation and discrimination in financial markets and to ensure a level playing field for all participants. But that didn't happen in the Trio matter. Given the Minister's background of shameless union bias, where he allowed one group to benefit at another group's expense, such as the secret side deal the Australian Workers' Union had with the cleaning services company Clean Event. The Australian Workers' Union saved Clean Event millions of dollars in wages, but in exchange for making a donation to the union, 5,000 workers lost $400 million in wages because they were forced to accept below award wages. The Minister divided the victims that were exposed to the same Trio crime, and with the same exploitation and discrimination, he allowed one group to benefit at another group's expense. He made a distinction without a difference when referring to the victims of the same Trio crime. He suggested the consumers in the union-led industry super were victims who are victims through no fault of their own, but consumers in the self-managed super funds put their money directly into trouble funds. The Administrative Appeal Tribunal played a big part in the prosecution of the financial advisor. But with the widespread cronyism and stacking coming out of the AAT, its integrity is questionable. In May 2017, Alan Jones and the Minister Peter Dutton on 2GB radio said the AAT President overturned Mr Dutton's visa decisions 4,389 times. The President's decision impacted on the refugee groups around Australia, organisations fighting against the unfair treatment of asylum seekers, such as Asylum Seeker Resource Centre, the Refugee Council of Australia, and Cawdor Centre claimed Australia's integrity was stained by an unfair system of cronyism and stacking. They said the impact of a AAT assessment carried out incorrectly means that asylum seekers could be sent home to face prosecution or even death. Attorney General Mark Dreyfus abolished the AAT in 2022. He cited a disgraceful exhibition of cronyism by the former government in appointments made over the last decade. That's the same decade the AAT president tried to discredit the financial advisor with his unsupported claim that the TRIO scheme was a high-risk product and not a fraud. It's a ridiculous claim considering that it was necessary to find fraud for the union-led industry super to receive compensation. ASIC frequently used the high-risk product claim at the AAT. It's a misleading claim and contrary to Lord Denning's legal precedent, fraud unravels everything. Once it is proved, it vitiates judgment, contracts and all transactions whatsoever. The minister was instrumental in turning the international organised crime into something less complicated, an issue about financial advice. ASIC struggled at the AAT in 2015 to find the breaches necessary to ban the advisor. The initial mud about what the financial advisor was guilty of was proved incorrect, but the mud stuck. The damage was done. When lawyers, barristers and a judge were convinced that ASIC had no case, to everyone's surprise, the court upheld the ban. Was this a case of protecting a rigged AAT decision? ASIC didn't act in the interest of the consumers. It helped the minister protect the union-led industry super at the expense of deceiving the rest of the financial market. ASIC supported the union bias and the politicisation of the TRIO crime.
This inquiry is principally focused on how ASIC deals with reports of misconduct and whether it is effective in enforcing the corporation's laws. And of course, we're doing that because we want to make sure that we have fair and clean financial markets and that we can protect mum and dad shareholders.
How did ASIC deal with the John Hempton misconduct report? Hempton identified potential fraudulent conduct in the Australian registered Astara TRIO fund. His report to ASIC was sparked by his concern with the link between the Australian registered TRIO scheme and the United States fund called Paradigm Global. Paradigm Global was owned and operated by Hunter Biden, and Hempton found that it had a troubled past. However, there is no evidence that the Australian courts or the Parliamentary Joint Committee investigated the Hunter Biden link, despite it being of concern to Hempton. There is also no sign that ASIC investigated the international organised crime gang that were accountable for the theft of mum and dad's superannuation. The New South Wales Supreme Court found the TRIO Capital Director, Sean Richard, of dishonest conduct while running a financial service business. It was of no value for ASIC to pursue the international crime. That would have only revealed ASIC's limited power in international jurisdiction. The better solution was to turn a criminal matter into a financial advice issue, a 360-degree turnaround. It was easy for ASIC to ban a financial advisor, and after all, it was simply following the minister's directive. As the minister's office allegedly controlled ASIC, that made the minister the puppet master. What extent of the financial market did the puppet master control? Did the puppet master control extend to the Administration Appeal Tribunal? ASIC and the minister undermined the credibility of the do-it-yourself sector, the the self-managed superannuation fund trustees and direct investors. Fault and responsibility was attributed to a specific group of financial advisors and consumers. Financial advisors from that specific sector faced prosecutions, while the consumers faced a barrage of misleading and discrediting comments. The prosecution of the financial advisor was a blow to an entire sector of the financial market that had invested in trio products. The bias of ASIC and the minister became apparent in the language used. For example, money disappeared either due to fraud or due to a high-risk product, depending on who is being supported or who is being discredited. The trio victims classified as not at fault or money placed in a troubled fund, again either to support or discredit consumers. The varied classifications do not reflect a proper criminal investigation, but more reflective of anti-competitive behaviour. It is perceived ASIC handled the complaint about the largest superannuation fraud in Australian history with deception. It reached an outcome that benefited ASIC and the minister. They protected their own self-interests by throwing the mum and dad shareholders onto the scrap heap. Can the Senate understand how ASIC dealt with the report of misconduct about the Trio capital scheme when there is no ASIC report about criminal misconduct by the overseas entities? The naming of the Trio mastermind by the New South Wales Supreme Court was flipped 360 degrees by the minister's directive. Was the push by the minister to prosecute the financial advisor his revenge for the loss of the AWU slush fund money? There is no way ASIC could protect mum and dad shareholders and support the minister's union bias at the same time. By supporting the minister, ASIC no longer effectively enforced the corporation laws or maintained a fair and clean financial market. Before the minister redirected ASIC into prosecuting the financial advisor, wasn't ASIC conducting a criminal investigation?